1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်22 Mountain Appellant vs the Union of Burma Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Appeal before ဦးစိန်သင် Judge Mountain Appellant vs the Union of Burma Respondent Right of private defense reasonable apprehension of grievous hurt being caused deceased rushing forwards holding a torch held the point that remains to be considered is whether the appellant was in such a predicament as to cause reasonable apprehension on his part that death or grievous hurt would otherwise be the consequence if he had not exercised his right in the manner he did. It is clearly in evidence that as soon as the deceased saw the appellant, the former rushed forward, holding a torch in his hand. The deceased was in such an agitated frame of mind, besides being inebriated, that it could safely be presumed that he did aim a blow at the appellant with the torch. As both of them were face to face with each other, the part of the body aimed at by the deceased could not be other than the front part of the head of the appellant. It is common knowledge that 3-cell battery flashlight is quite a heavy article, about 1 foot in length and nearly 2 inches in diameter, with a reflector made of heavy glass at the top measuring about 6 inches in girth. In the circumstances, it would be safe to infer that the appellant reasonably anticipated grievous hurt at the moment when the deceased trained his torch at him. The State vs. MAUNG, BLR, 1946, page 50. MAUNG vs. the State, 9, LBR, page 191. MAUNG vs. the State, RLR, 1947, page 50, refer to Ulanyo Udema for the appellant, Uba P, government advocate for the respondent. Usain then judge. It appears that on the 3rd lesson of the Bodwe, 1325, BE, 23, June of 1963, there was a ceremony at the house of one Kunyansei of Yuanzai village, which was attended by the villagers of the neighboring village. Among them were the appellant Denyu, a resident of Baoseng village, and the deceased Song Wei, who belonged to Guiji village. At about lamp lighting time, while MAUNG, plaintiff witness 1, brother of the deceased, was on sentry duty at the village gate, the deceased went past the king post, accompanied by 2 policemen. The deceased told MAUNG that a Guiji folk held out a door at him. MAUNG then followed up the deceased to the house of Bao A, plaintiff witness 7, where the deceased looked for the fellow who threatened him with the door. Not finding him there, the 2 policemen went away, but the deceased continued his search and arrived at the house of one Ko Tui, accompanied by Ko San Maung, Ko Tin La, plaintiff witness 2, and Ko Kaung Ji, plaintiff witness 9. They found some person on a cot in front of Ko Tui house. Seeing someone sitting on a bench inside the house, the deceased flashed his torchlight towards him and discovered that he was the appellant Daniel. What actually took place after that was rather obscure from the evidence obtained on the record of the trial court, but it can safely be made out that the deceased, on finding the appellant, rushed into the house, and in a melee that followed, he sustained a stab wound resulting in his death. In the lower court, the appellant cited a two-pronged defense, one of alibi and another of self-defense. The trial judge overruled the plea of alibi. Regarding the plea of self-defense, the lower court has nothing to say except to convict the appellant under Section 304 of the Penal Code on the ground that he might have acted on provocation given by the deceased. In the course of his argument before me, the learned counsel for the appellant has abandoned the plea of alibi, but strenuously contended that the act of the appellant fell squarely within the ambit of Section 100 of the Penal Code. The following grounds were advanced in support of the plea. 1. The deceased was a dangerous character with 10-year jail term for murder to his credit. 2. The deceased was inebriated at the time of the incident. 3. The deceased was desperately in quest of the appellant, bent on doing harm. 4. The deceased, when he wanted to the appellant, was holding a 3-cell battery torchlight, which, if used as a weapon of offense, could cause grievous hurt to the person attacked. 5. The deceased sustained only a single stab wound, which was the result of a random blow given by the appellant in his fear and excitement. I have no doubt that the facts and circumstances stated above are not unwarranted by the evidence obtained on the record of the trial court, but while these facts by themselves may be sufficient to establish right of private defense, it would be necessary to further consider if they could be said to have occasioned such a reasonable apprehension of either death or grievous hurt on the part of the appellant as would justify causing death to the deceased. No hard and fast rules could possibly be fixed regarding the test to be applied in such cases, and each case must be determined according to its own merits, but some general principles have been laid down, of which the most famous is that of the eminent jurist Maung, quoted with reverent approval in the State vs. MAUNG 1, to the effect that when the assault has one assumed a dangerous form, every allowance should be made for one who, with the instinct of self-preservation strong upon him, pursue his defense a little further than to a perfectly cool bystander would seem absolutely necessary. Also, it is a try saying that when exercising the right of private defense, it is difficult to expect the person to weigh with golden scale what maximum amount of force is necessary to keep within that right. In the present case, the appellant gave only one single blow and a random one at that. He did not do anything further, but ran away as soon as he had the chance. No doubt the blow was with the dagger, but considering the fact that daggers are commonly used by the village folk, he could not be expected, in a moment of peril, to refrain from employing the use of such a dangerous weapon. Therefore, the only point that remains to be considered is whether the appellant was in such a predicament as to cause reasonable apprehension on his part that death or grievous hurt would otherwise be the consequence if he had not exercised his right in the manner he did. It is clearly in evidence that as soon as the deceased saw the appellant, the former rushed forward holding a torch in his hand. The deceased was in such an agitated frame of mind, besides being inebriated, that it could safely be presumed that he did aim a blow at the appellant with the torch, as both of them were face to face with each other. The part of the body aimed at by the deceased could not be other than the front part of the head of the appellant. It is common knowledge that a 3-cell battery flashlight is quite a heavy article, about 1 foot in length and nearly 2 inches in diameter, with the reflectors made of heavy glass at the top, measuring about 6 inches in height. In the circumstances, it would be safe to infer that the appellant reasonably anticipated grievous hurt at the moment when the deceased trained his torch at him. In the case of MAUNG versus the State 2, where the deceased rushed at the accused and with a heavy weapon and showing every intention to assault the accused, it was held that the accused might reasonably anticipate grievous hurt if the deceased blow fell on him, and consequently he had a right to use his spear to defend himself against the blow, even to causing deceased death, and that his act was fully justified under Section 10 of the Penal Code. No doubt there is this difference, that in the case cited above, the deceased was armed with a heavy weapon, whereas in the present case before me, the deceased was holding a 3-cell battery torchlight. But the differences seem hardly material in view of the fact that the nature and the size of the article which the deceased was holding was such that, if used as a weapon of offense under the circumstances prevailing in this case, it could surely cause grievous hurt to the victim. On a careful review of all the facts and circumstances obtaining on the record of the lower court, I find that, at least, it is a matter for doubt if the appellant had exceeded the right of private defense, as pointed out in the oft-quoted ruling Point versus the state 3. The test is not whether the accused has proof beyond reasonable doubt that he comes within any exception to the penal code, but whether in setting up his defense he has established a reasonable doubt in the case of the prosecution and has thereby earned his right of an acquittal. Applying this principle to the present case, I am of opinion that the appellant should be given the benefit of doubt. This appeal is therefore allowed. The finding and order passed by the lower court will accordingly be set aside, and the appellant will be acquitted so far as this case is concerned. The case is classified as mistaken.